Property and Legislative Committee meeting for Wednesday, March 19th, 4:30 p.m. to order. I will take roll call. I believe we have a quorum, all present. I would like to approve the agenda and the minutes from the February 26th meeting, if I have a motion to do that.
So moved.
Second.
All in favor to approve the agenda and the minutes from the February 26th meeting, say aye.
Aye.
Aye. Opposed? That is carried. That motion is passed. Any public comments on agenda items? Do we have anybody present physically or electronically?
No, nothing. No, we've got, like I said, Attorney Abson, Trustee Saylor, yourself, and then in person here we have Trustee Humble and President Mansell, myself.
Okay. So no public comments on agenda items. Number 6, chairperson comments. I do not have any. I think we can quickly go through 7 and 8 to get to the facility use agreement, which would be where we need Nick's input.
Okay, so we'll go to the DMI update. Obviously, we discussed last month. I got the ad hoc committee going together. Those minutes and video have been displayed on the village website. As in for contact with DMI, I've sent a weekly email to Mr. Moore and haven't had no response back. So at this point, that is my update on the DMI property.
Okay. Any discussion on DMI?
Yeah, I have a couple of questions for Attorney Apps, if I could, please.
Go ahead.
So Attorney Apps, my name's Eric Hummel. I have been on the board for months as opposed to 2 years and still continuing to research and get caught up. Could you tell me and just help me understand how long you've been the attorney for the village?
So I probably have been primary attorney on this since sometime in 2018, I want to say. 2018, 2019, I took over. Previously, my former firm, it was La Chapelle, Krishak, and Nettesheim. Before that was Brazo, La Chapelle, Krishak, and Nettesheim, was representing the village for a long period of time. JP La Chapelle was doing it. Then it was Skip Wafel before that, I believe. But for me, it's been about 6 to 7 years.
Yeah, thank you very much. I did read your lengthy and very well done letter to DMI, I think in 2018. I thought it was very well done. The question I have is, during the time you have been the attorney, was there ever, to your knowledge, a bond from DMI to the village?
I don't believe so. So I've looked through the files that I have. I believe I have all of the files that the former firm had from DMI that were transferred to me by JP La Chapelle in 2020 when I went out on my own, and then JP ceased practicing municipal law altogether. So I haven't been able to locate a bond, anything that's been signed, I haven't located any document that indicates an application on their part. I mean, there's a lot of files to dig through, but I think I know I've been through all of it at least once. And I asked my assistant Tammy to take some time to go through, because Tammy has been with me since that time in 2018 as well. But I don't have any evidence of any bond actually having been applied for or secured.
Yeah, well, thank you. You're usually very complete and well-researched and detailed. So if there was a bond prior to 2018, it still wouldn't be relevant today, would it, in terms of any action we're doing with DMI?
I wouldn't say categorically that it isn't relevant, but probably not. Yeah, you're right about that. I doubt that it would cover. I doubt any bond company would have committed it through everything that we've been through. But I should be clear, my files don't contain only 2018 and since. I have all of the files that the old firm kept that I'm aware of and that JP was aware of having existed at the time.
Okay.
That were in the former firm's possession. And I
Thank you
still
very
didn't
much.
find it.
Yeah, that's very helpful. It clears up for me, and I think perhaps for some citizens, if they're aware that there is really the probability there being a bond ever is very low with the village, and even if it was, it's very unlikely that it would be in effect at this point. So thank you.
Okay, thank you, Eric. Any other discussion on DMI update? Go ahead.
I do have one other one. So I am going to attend the Chamber of Commerce Spring Legislative Breakfast on Friday with some of the representatives there. So if there are questions that you would like me to ask, there's an open period for questions. I think several people that we've already contacted are going to be there. If there are some things you would like me to ask as representing the village, I'd be glad to do that. So I'll check in with all of you before I go.
Yep, thank you.
Mhm.
Path forward with DMI is we're having the ad hoc committee. We're going to be meeting early April and discussing some possible state or federal assistance, how we can move with or without DMI to try to get possible movement on that property. So that is still just in early stages of trying to get things going with that property. So we will continue to update this committee and the board.
Yeah, and I'm sorry to be so dominating of the conversation here, but I have one other thing. I met with the head of the Wisconsin Rapids Chamber of Commerce and asked her about how the Rapids came up with being able to acquire a AI creation, $200 million AI creation building and so forth on the old mill property in the Rapids. And she gave me some background about how they went about doing that or whatever. And if we haven't explored their process, it might be worth doing that, because what she told me is they had a lot of interest from potential users of that space. So I can give more information to you all in the ad hoc committee if you haven't already done that.
Yes, please. We have not gotten a significant amount of information on that.
Okay.
Thank
I'm
you.
done.
Okay. Anything else on DMI? Hearing nothing, moving on to update on the 160 Market Ave property.
So in your packet, I've included the two financial recordings of checks from Cyber One for the $10,000, 5,000 from each one of the owners. So we are working on getting that obviously shored up the payment. They do have the 60-day notice that I sent out for them. Neither one have signed and sent it back to me. That we talked about the last meeting. So at this point, Cyber One has paid the 10,000, made the payment for February. March is supposed to be in the way. I will keep reaching out to them to get that. And end of April is when our 60-day agreement that they need to come up with a plan to move forward with their property. So at this point, we will kind of be status quo until we hit that April date, which they know about. And I've talked to them both personally on the phone, and they understand that after April, we need a plan to how they're going to get us paid back the 20,000 to get back on track of the TIF agreement. And moving forward, we need to see those payments monthly.
Okay. Do you have update on the amount that they are in arrears still with this $10,000 payment?
I have it with me. I believe it.
We were like 37,000. Now we should be less. You can just update.
37,200 minus the 10,000, so 27,200.
Okay. Thank
So
you.
I have a question. This is Eric Hummel again. Will, this committee be meeting before the 60 days is up? The 60-day deadline for them?
It'll depend on what the new chairman sets for a date after the reorganizational, but there should be a meeting before the March board meeting.
Yeah, I do think, I'm just gonna make a suggestion that we have at least a discussion about what our options are. If, by that meeting, it's only days, it might be only days away from that deadline. If nothing is forthcoming or they don't meet that deadline. Yeah, I'd like to start that discussion about what we're gonna do beforehand as opposed to waiting whole another month afterwards. And so forth. So I'm just asking, maybe that could be an item for the next meeting.
Yes, it should be on the agenda, and we do have legal representation, so that would be a question that we could throw out right now. What are our legal avenues if they don't keep up on payments? I mean, if they're making their monthly payments, they're still in arrears. There's really two different things. If they stop making payments altogether, or if they just are still in arrears and continue to make payments. So I guess I would ask that to Nick, if we have, what are our options from the village standpoint?
So so first of all, I guess my recommendation would be is if they're making good faith payments and they're of a significant amount, usually it's going to be more cost effective to even have them be a little bit behind than it is to sue them or anything like that, because it's, I mean, legal process is costly, and even if um, there is a recovery of legal fees, which can occur in some cases. The it's a actual practical recovery of those is difficult in some cases. And again, I guess I'd point out these are people that are located out of state, so legal process on them is by definition a little bit more difficult. And you know, there's a procedure, and the upfront costs are typically borne by the village. So there is the development agreement does have a default does have default provisions. So if they are in default, you can assert that there's been a material breach. The village can, first of all, the village does have the ability to recover its costs, legally speaking, from them, from CyberOne, under the agreement. There's also, let's see. So, you can also terminate it, and if we have and as security there's a mortgage, the village is able to assert foreclosure of that on CyberOne. So the village can get the property back. Now, on a practical level, again, the determination of whether that makes sense is up to the village. In some cases, it certainly makes sense to foreclose if you get somebody who's ready to come into that property, occupy it, and utilize it. But yeah, so the village, the development agreement does give the village some options, and you can get CyberOne out of there if you need to. I would say that if they, I think that it is generally, I advise clients that are in a situation like this, whether they're municipal or otherwise, to explore all options before you do that. Now, sometimes I will say sometimes you want to assert, you want to give them a formal notice of default, and you want to let them know that you're intending to assert your rights, or that you're reserving the right to assert any right that you have. But otherwise, it is, giving them an opportunity if they're making good faith payments. It's not a DMI situation just yet. So that's probably where my recommendation would be. But there are limited rights under the development agreement.
Okay, thank you very much.
So
Go ahead.
I got a question for Ben. Do we know, or do you remember when we first gave them that TIF loan?
The date of the development agreement is April of 2017, Eric, just.
Okay, so 2017, minus this $10,000 in payment now. So if we just say 37,000, it's about $1,200 a month monthly payment. That puts them at approximately 30 months behind. So over 2 years, that puts 219. So they they took the loan, or we gave them a loan. They had their property, they paid on it, and then for whatever reasons, they've been behind over 2 years. So they know, we know. I'm having a little hard time swallowing good faith payments. I think we got to kind of push a little bit, I would say.
There's one other thing I would add as a corollary, kind of with what Eric is saying, if I may, and that's that the whatever the village decides to do, whether it's I guess if you say there's 3 ways to go about it. One is to just give them more time without uncritically. The other to kind of push a little bit and give them try to force things a little bit without taking them to court or going with foreclosure, or the full-on foreclosure approach. If you do sort of a pushing them like Trustee Saylor is suggesting, without going the whole way, you can do that without waiving any rights under the agreement. So in the default section, there is specifically a waiver section that says that delaying insistence on specific performance of the contract does not act as a waiver. So if you did take that approach, you wouldn't be doing it at the expense of the ability to either back off more in the future or go the full way. So you do have the full range of options.
I don't want to prolong this conversation too much since we're still 30 days away, but it also makes me wonder if there's value in inviting them to come to our next meeting and share what their plan is verbally in front of the committee. That would be an opportunity to hear that and then express whatever concerns or whatever at that point. So that might be something to consider as well.
Right now, we've got the April 29th letter that's been sent to them. And at that point, I believe with Trustee Humble, at that point, we decided if we didn't get any response back, we were going to go to Nick and get legal and do our next step moving forward.
Good, thank you.
I guess one last parting note is we already gave them a reprieve, or I don't know what the exact word is, a couple month
9 months during COVID, we gave them
so if we look at that, now we're pushing 39 months without payments. So just something to think about.
Yep, thank you. I think that we want to try to get them, in all honesty, I think we want to try to get them caught up, and we want to give them time to come back, and hopefully they do come back with a plan to get back on track. That is the first goal, is to get them back on track, catching up the $27,000 they're still behind, or at least have a plan to do that in the near future. At that point in time, if they come back, I think it might not be a bad idea to have them show up and present their plan. So we're expecting a plan at that time during the next committee meeting that would kind of put them to task to have it done and at least come and present. And then we could go from there, depending on do they have something or do they not have something?
Absolutely.
That's my thought.
I agree with that. I'm not saying that we have to foreclose on their property, but we just need to be prepared with whatever is discussed or whatever that we want to push a little harder than what's happened in the past.
And I agree with that. The last committee meeting, we recommended that we were going to push them to try to get them back on track. So I think that is a good plan. So we have for the next agenda, I guess I'm hearing that we would recommend that they come. We would ask them to come and present their plan. Is that what I'm hearing with the two trustees on board?
I'm all for it.
I guess it would depend on when their 60 days. You said the 29th, Ben?
Yep, 29th is their 60 days.
April
So-
29th, so that's just over, that would be a couple days over if we have the fourth Wednesday, depending on who's chair of this committee.
Yeah.
So we can put that down as a future agenda item, and then, Ben, if you stay in touch with them and let them know our thoughts.
Yep, they definitely know you guys are concerned, and they, some of my fear is, again, they could just pack up and leave us with $136,000 debt in the building. I mean, they're quite aware of that too. So, I think working with them now what we are and hope they come up with a plan will definitely keep them within check. I don't think the village wants to, take on another building and try to figure out how we can, recoup our costs on that if they do walk.
No, I think everybody wants them to catch up and stay in there. We just want them to have a plan and execute that plan. Okay, anything else on the CyberOne TIF loan? Okay, moving on to the next agenda item, a discussion of possible motion to pass a facility use agreement. Now, you want to go through briefly, Ben, the two different drafts, and the draft one I will highlight is the old draft. It still has a spelling error. We do understand that we do use draft one, it will have that spelling error corrected.
So when this got brought to me in January, I sent over this draft number 1 to, Attorney Apps. Had him look it over prior to our pit meeting. Attorney Apps, gave us some pointers, suggestions, however you want to call it. And we rewrote it to draft number 2 to include, what, Attorney Apps, asked me in an email to include in that. So that's where we come up with the two agreements. I think we just start with that conversation. So draft 1 was
Yep.
one we come up with ourselves in the village. We sent it over to Nick for approval and comments. We brought that back to committee. So I guess I'd like Nick to review, I guess, the comments, the reason we reviewed it, to draft number 2 and the reasons why we added those language to it.
If I may interject prior to Nick, I don't mean to interrupt you, Nick. One of the concerns was the length of it, and is it too much? So if we go with a shorter version versus the longer version, from a legal standpoint, are we putting the village at risk? Or I guess it was a simpler, sometimes is better approach. And we want to hear from your thoughts. Does any trustee have any comments before Nick begins?
No, I just have to do it after.
I guess the only concern that I had is or the questions I had was the prohibited things, making it's a little bit too granular. I don't want to limit whatever people are trying to rent those facilities for. So that was just my question on if we needed that or not.
You're talking the top of page 2 on draft 2.
Yep.
Okay, Nick.
Thanks, Rick. Well, so I'll answer trustees Saylor's question first, and that would be that really it's up to the village what the village wants to prohibit or not, broadly speaking. When it comes to some of the individual things, I think generally these sort of 7 items that are listed here have various levels of risk associated with not putting them in there. So, for example, if you say if you take out the smoking is prohibited, criminal activity is prohibited, I think you could probably make the argument that a reasonable person wouldn't expect that criminal activity is allowed by the village by virtue of signing it. But I think, and I presume that any smoke-free areas are designated as such. by the village. So, there may be some things that are actually redundant relative to what the village's actual posted restrictions are, and maybe some of these can be just posted in the relevant buildings, and then are covered by the cleanup. If there are things that if you just generally want to allow food and beverage preparation, then and not prohibit it, that's fine. But maybe if there's a kitchen or something, or a particular type of facility, you just want to maybe post some, sort of specific facility rules there or something like that. So that really, I think, depends on how the village looks at these things. If you want to take the strictly prohibited conduct section at the top of page 2 out, it's probably, it's not a huge liability risk, although I would say the alcohol related stuff is probably, and the charging admission to third parties might be things that you want to prohibit, generally speaking, just because of the secondary risk that those might be associated with. So, but that's really up to the village. And then on that same page, since we're right there, engaging in those types of conduct. I mean, I think you could probably, if the village doesn't want that language about, hey, we reserve the right to deny use of the facilities for these specific things, then, if you take those out, I mean, that might limit the village's ability to be viewed as non-discriminatory if there's conduct that is, that by certain organizations or certain individuals that's not appropriate. But I think there's an extent to which that probably is understood to a certain extent, as long as if somebody is being banned, you're very clear about it when that ban takes place, and that probably this committee is making that determination. You can still, I mean, by removing that, you can still ban people probably. But what I would say is that when you look at page 1, I did add the municipal corporation under indemnity requirements. Keeping the hold harmless in there is a good idea. Licensing, getting the relevant licenses. I think that the hold harmless is good to keep, but I also think that the first paragraph is important because it does include the it's very clear that the village is not assuming liability for what's going on there, and that none of you are, as trustees or any individual employees or agents, are liable for anything either. So if you are going to trim the second page, I think that this paragraph in particular is very important because it puts people on notice about that. And then what I added under the facility and equipment use was just a couple of, I think, a little bit more detail about how it should be returned. I think that making it clear that the facility user is responsible for cleanup costs and repairs, so that they know. I don't think you want to have any disagreement. Well, I shouldn't say that because there might be disagreement regardless. I don't think you want to have somebody to have a reasonable legal disagreement that they didn't know what they were responsible for in terms of costs. And so, my view on it, generally speaking, is that the first page is pretty, shouldn't be changed too much. And if you want to make the second page just a signature page, or try to put it all on one, which is maybe easier said than done, but possible if you trim some space in there. That I think is probably the minimum that I would recommend that you utilize.
So
Does that
I
an-
would,
Go ahead.
just as a clarification, this is not for parks. This is just for basically village, fire department. What facilities are incorporated in this? facility use agreement?
This would be basically the fire department, village garage, and, the parks, when Little League uses the parks. And when the Lions run a bigger event in the parks. We have a normal sheet that we use for families that rent the parks to hold graduation, things like that. This is more for organizations that are gonna be using our facilities, the Lions Club, PIVA, Port Arts Fire Department, to those extents.
So what I'm hearing is it's mainly village departments or village organizations.
Is it really just that it's an organization trying to use any of the village property? Sounds like it's still for parks. It's rather the break is the personal use, family use versus organization use. Is that correct?
Correct, this is more organizational use.
I
So
guess
what
if I
about-
may, I would
Oops.
suggest that anybody who's using a facility for any sort of significant use, that you have some sort of agreement, because if you let people use facilities that are village owned without any sort of monitoring, then I think there's a potential for liability there. I think generally speaking, it's not a big ask to have somebody who's wanting to use the village for like a big event to sign off saying that they're, they understand the village isn't liable for anything they do there.
Yeah, we could definitely add this to all of them. That wouldn't be a main. Once we put this in place, we could add this to our weekend families that rent the parks for graduations and things.
So if I'm understanding this right, it's two different agreements, one for more personal graduation party, that type of stuff, and one for organizational ones.
Correct.
And then, so Nick, from what you said, having this kind of language in the family type one, do we just make one, or do we just make one agreement instead of having two separate ones? Do we just make one all-encompassing document instead of having separate ones depending on the use?
Yes, I
My
mean, the difference,
I'm sorry, go ahead, Ben.
the difference with the park rentals from graduations, we do charge the people to use this. Where this is using our own facilities, our own groups in town, we do not charge them to use these facilities.
I
So
would
can we-
recommend that there's that there isn't a difference, because people paying doesn't, I mean, it doesn't change things tremendously in terms of liability. I'm not sure that it would at all. I think that it probably makes sense to have everybody who's using a facility that's not the village itself sign off on this stuff. It's because, again, it's a relatively, and I would recommend using the same one. If you're gonna, whether or not you truncate the second page or even eliminate the second page, I don't think that really, there should be, my view is legally, there's not a difference so much from the village standpoint in terms of whether the problem is caused, or the potential problems are being headed off by, whether it's by an agency or by individual families. I think you still have the same potential issues without, I mean, the only thing you don't have with families is that it's not, there's no kind of representative who's being responsible for a whole group. The way that, I mean, although I guess with families, I guess theoretically it is too. So I think that it's beneficial from a legal standpoint. I don't know that that it makes a lot of sense to have certain classes of people who can have events in the village, and at village facilities without having to sign off on the liability for it, and others that don't. That just, except for the village itself, actual village business, if that makes sense. And I'm sorry
No,
if
I
I
would-
cut you off, Betsy. Was that you that I didn't mean to do that?
No, that's okay. And that's just what I was going to say, is I think it should be, I'm okay with both of these pages. And then for no matter what the facility is being used for and by whom, it should be the same. And then we can put, there's room on the bottom of that second page for like that office use only type of thing to be able to indicate if it's a nonprofit or if we're charging them, where if we got payment, was there a receipt? Was there any damages, stuff like that. So I guess my opinion would be to keep with the 2 pages. And then just use it for everybody who is using it, whether it's a organization or personal. But it's for the committee to decide, I guess.
I would agree.
I don't see any harm in keeping all of this verbiage, especially if it adds any legal benefit to the village. I guess I will turn it over to the other 2 trustees to see if they have any issues with keeping the strictly prohibited verbiage in and the basically discrimination type verbiage.
Well, I'll
So,
comment. Go ahead, Eric.
Go ahead, Eric.
Actually, this isn't that long. I mean, if you look at the first page, almost a third of it is at the top where you just simply fill a couple things out, and page 2, the second part of that is signatures. So it's really about a page of context. And so what I would recommend is keeping them and eliminating number 3, 4, and as not needed, and keep 1, 2, 5, 6, and 7.
Trustee Saylor?
So
Any
my
comment?
question, yeah, so my opinion is we don't need any of that. The more granular we get, the more issues that could arise. Who's gonna police this? All it's gonna take is somebody walking by, not like whoever's at the park or whatever, and see them shaking dice or something, who knows? And then it's gonna blow up and be like, well, they were doing this, and then we got the he said, she said stuff back and forth. If we just keep it general, and Ben ultimately, or Kim or Diane are ultimately going to be the ones that the person or the organization is going to come in and fill out this request for. They're going to ask, maybe their standard questions. What are you going to use it for? This, that, and whatever. And then Ben or whoever is going to bottom line it.
It'd be myself, correct, Eric?
Yeah. So Ben would bottom line it. So he's going to do his due diligence. I just want to, I want to stay out of the, everybody carries a phone, they take a picture because their ex-mother-in-law is over there, what's one of the prohibitions, on some kind of motorized wreck vehicle or a 4-wheeler or something, I want to stay out of all that. So that's my opinion on why once we start making all these little things, then we have to follow them. Well, that's just my 2 cents.
You do have to follow them, right?
Are there any that you would be okay leaving in, or you're talking about removing them all, Trustee Saylor?
I would delete the whole second page.
Yeah.
We're not going to discriminate. We don't, all of that's going to be pre-approved by Ben. We put them in that position to ask those questions and stuff like that. I mean, if you want to leave everything in there, I just want to know who's going to police it.
Okay. Does it need to be policed? Is that fair? Does somebody have to go around and police it, or is it just an expectation that we're putting this forward so we expect them to follow these guidelines?
So the world is a very fickle place right now. I would like to assume that everybody would just let people use the facility, they're using it and whatever, but there are people that I don't know, I guess I don't want to say what people may or may not do, but it just, yes, it protects us in liability, but it also could create liability because it could create other instances of just stupid crap that's none of our business. That's the only reason that I question it.
I guess
I-
for me, sorry, it is, I mean, it's, if it's municipalities a facility, it is somewhat our business. Ben, are these things on, in any of that documentation that is being signed now?
No, basically it is signed that they are liable to clean everything up and they're liable for any injuries that happen there and the place needs to be clean. And if not, they don't get their $25. We keep the $25 security deposit.
Okay,
And it goes on as they get the keys, Diane, Kim, they come sign them, I look at them. And they come grab the keys and then after the weekend, they get a hold of me, I go down the park, make sure it looks good. If there's issues, which we've had over the years, if people left a mess, I go down there, take pictures, call the owner up and say, you're not getting your money back because of X, Y, and Z. And we move on to the next one. I mean, we haven't had any issues, with the rentals. I mean, we have people on staff that go down in the morning, open it up and lock it up at night. And like I said, we're probably in the last 20-some years, I've had two people that I had to call. One in previous administration that we had issues down in the park. Otherwise, we haven't had any issues.
so question for Nick, how would you suggest us keeping tabs, or what, if somebody breaks the smoking in any area designated as smoke-free zone, how would you suggest the village policing that? Or I guess Eric, sorry, I thought.
Yeah,
sorry, you know.
I don't think we need to police it. I think we need to be able to adjudicate somebody who has a problem with it. And that could be the administrative coordinator taking a quote complaint and making a judgment call about, you know what, yeah, grandma was using dice. I understand that. That's not a huge violation and you don't do anything with it. But I do think you need some adjudication of some of these things, but I don't think somebody has to walk around and be the police
Bingo
of an
police.
activity.
Well,
Trusting
to
people
answer,
that
I guess
people-
to answer the question generally, the overall, the purpose is, number one, if something occurs and the village gets blamed by a third party, then the fact that the offending party was aware that it was prohibited conduct gets the village off the hook further, if there's any issue. But also, the key is not so much that the village is obligated to monitor it on an ongoing basis. So lots of organizations, municipalities, and so forth have agreements like this. Mid-State has one that's really, the print has got to be like 8-point font or something like that. And I know this because I've used Mid-State for depositions in the past, at the Stevens Point location. And there aren't people going around checking on things actively, but just the general awareness that certain things are prohibited. Kind of what it does is it promotes, I guess, it discourages antisocial conduct, and it gives the village a way to adjudicate it, because otherwise, if somebody has a complaint about about something that had a negative impact on somebody else from, say, under the first agreement, it's just a very general circumstance, and somebody could argue about the finer points of it and say, well, you didn't tell me that gambling was illegal, and so there's if there's a fight over a card game or whatever it is, it's just something the village should have expected could happen. So again, this is kind of a situation where, as long as the village is not discriminating in how it applies the rules, it's not going to it should not create more problems than it solves. But the problem comes when the village ignores its own rules. So if there is no intent to really take this seriously and just put this down and I guess I don't mean this in a negative way, but I'm just saying if there's no intent to actually follow through on holding people accountable under any circumstances, and the idea is, yeah, let's put this in writing so that people then are discouraged from doing it, and that ought to be enough. Well, then there's probably no point in doing that and being specific about it in any way, shape, or form. So it's just it's how the village, I guess, intends to intends to do it, intends to act on it. So, maybe what I would suggest, if there's a lot of conflict about this, or not even conflict, that's probably overstating it. But if there's disagreement about that sort of thing, it might not be a bad idea to, back up the discussion, or maybe have, maybe have Ben, I guess, think about this for a month. Like, how am I going to interface with these rules? And that might inform it a little bit better. If the idea is that enforcement is going to be more general, then I think the first page added liability protection stuff is critical, and the second might end up having more of an effect that Trustee Saylor is intending. Whereas if the intent is to be a little bit more proactive in enforcement, then the second page can be pretty useful.
Thank you, Attorney Nick. So what is the village's thought, the trustees' thoughts on the enforcement piece of this?
If I add, definitely every organization that uses it definitely will have to do a little more in detailed description of what they're doing. I think that's where Trustee Saylor's coming from. And if it's the Lions Club and they're going to be selling beer, obviously they need to include that in the permit. If they're going to be playing bingo, they need to make sure the gambling license is, they have the license and they're having that specifically in the rental. If the Little League is going to use four-wheelers to drag the field and things like that, they need to have that included when they're going to use the facility. If the high school is going to use Ripple Creek and they're going to have a playoff game and they need to charge admission, the school is going to have to write down that they're going to be charging admission to the fans that come to Village. So, it definitely adds a lot more. I do agree with Trustee Saylor on that. So I definitely got to get on my A game when these people come, because there's a lot more questions probably need to be asked than in the past. If that makes sense to the trustees.
It does to me. Nick, I will ask for your input after the trustees speak, if that is appropriate coverage for the village.
Well, my point is, if we don't believe in any of these, then of course we don't do them. If we believe some of them are important, let's keep the ones we think are important to spell out. And I see 1, 2, 3, I see at least 3 of them that I don't think we need to have in there. But I do think there are 4 or 5 of them, 4 of them at least, that it's important to spell out for clarity's sake.
Which 3 and which 4?
It means if there's a complaint, it has to be adjudicated, it has to be checked out. And if you don't think it's important to check them out, then we probably shouldn't need them. But some of them I think would be worth checking out.
So which 3 are you putting and which 4 are you putting in which
I
category?
would again eliminate 1, 3, and 4.
So eliminate those ones and then keep.
I don't think they need to be in there, but I think the other ones.
Is there from I hate to say a rating standpoint, Attorney Epst, is there any that you see that are more important from a village liability standpoint or use standpoint?
I guess I tend to think that the alcohol, gambling, and charging admission are probably the highest priority. The only reason that I don't mention the use of motorized recreational vehicles specifically is because I think there probably is an enforcement mechanism for disorderly conduct with such a vehicle if somebody is disruptive with a with you know, an ATV or something in a place where an ATV ought not be. And maybe you rely on the police department to do that in that case. But I think that, you know, and I think that I talked about smoking and criminal activity before, and food is a little bit less risky. Although you know, I don't know. I know that daycares deal with food related liability quite a bit. And I'm sure anybody who has kids can probably know exactly what I'm talking about. The village probably doesn't have that same kind of thing, but I think that the alcohol gambling and making money from renting the facility are issues that can really cause potential problems.
Trustee Saylor?
So we had a power outage here and he's trying to get back on.
Okay.
So we're gonna make a motion tonight? Is that what we're gonna do, or we're
I
gonna keep
would-
discussing?
I would like to make a motion and get this, try to get this to the board. And because then we could go through the next two and where we're gonna put it. I think, we're close, and with, Attorney Epps being on, I think we're closer. We just got to come agreement what we would like to do and what we'd like to include or not include. So let me know when Trustee Saylor gets on, because we'll have to make a motion and try to get moving on with this. Right now I'm hearing that he would recommend keeping 2, 5, and 7 in this section. And I would like to get Trustee Saylor's feedback on that. And I'm okay with that. It would clarify, hopefully it would help some of his
We'll get back on.
concerns.
Okay.
No, thanks, Rick. That's helpful to summarize and kind of narrow down what we're talking about at this point.
Yeah, once he gets back on, I'll try to summarize it and see if we can come to a motion. What I'm hearing is we would keep all of page 1 and then modify the first part of page 2 to include 2, 5, and 7, and keep the discrimination language. And then that would be it. Is he trying to get back on, Ben?
He said he was.
I had a couple of little hiccups, and it said it was automatically trying to get me back on, which maybe hopefully it's doing for him too. I don't know.
Yep.
Yeah, he's back on.
Okay.
Yeah, I just had to say it.
Trustee Saylor, I don't know how much of that you caught, what Attorney Epps was saying.
I know he was talking and then the lights turned off, so.
Okay,
Just
He was-
briefly, Rick, I can just
Go ahead.
repeat quickly.
please.
It was asked whether there were what the highest priority of that 1 through 7 sections would be if being forced to pick. And I said that I think the alcohol, the gambling, and the charging admission, making money off of it. Those 3 are probably the ones I'd see that maybe have the biggest risks that are not addressed elsewhere. Although it's worth noting, I did note that food consumption is an issue for places. I mean, daycares have to deal with that, like adult care facilities. It's more of I think that's maybe less of an issue here for the village. But I think the highest priority ones would be 2, 5, and 7 if worst comes to worst in terms of trimming.
And
Probably in roughly that order too, just incidentally.
I have a key to lock up, so yeah.
so the discussion, Eric, was if your thoughts on that, because we would like to get to a motion where we could move this forward and where we would put it. So right now it's looking at keeping all of page 1, modifying the top of page 2 to include 2, 5, and 7 is the latest proposal, and keeping the discrimination language.
I don't know. To me, it's still micromanaging. I look at that list and everything at a fire department Christmas party. We've done all of that except for criminal activity. You know, we're playing sheephead. the fees, like Ben said, for getting into a park, and it's all, I think for the facilities agreement, it's going to be those organizations where the baseball association or the school is going to charge a WIA fee because softball made the playoffs or something like that. If those come more often than the onesie twosies, then I think Ben can manage that himself. But to save time, to put this thing to bed, we can do whatever.
Let me ask one final question of Attorney Apps. If we remove all of this, does it put the village at any increased liability?
I mean, I would say incrementally. I mean, it's really hard to eliminate liability entirely. I think that if the concern is that the 1 through 7 are micromanaging, then I think that as a way to address that, then it has to be made very clear to and I guess by Ben, since he's facing them, to any organization, what the page 1 really means to them, which is to say, look, we don't have a list of specific prohibitions, but use your common sense. Anything that's in a violation of village ordinances, and also, you could get yourself in trouble in a number of different ways. For example, by excess consumption of alcohol and a few other things. So just know that the village isn't going to be responsible for any of that. And that's what this says here. I mean, that's the kind of conversation he's going to have with people, I think, to get the same effect on a practical level, if that makes sense.
It does. Ben, if we remove this section, what I'm hearing is that you would need to cover this, or whoever lets them signs this would have to cover these type of things with them verbally.
Yes, I mean, if that's again, I don't, whatever direction we go, I'll follow through and make it happen. If we go to that direction, then when they do the facility agreement, I will ask them exactly what they're using this for, and they'll have to type up a little more specifics on what they're using, if that's the direction you guys would like me to go, so that when I sign it off, we have an examples of all the activities that they're gonna be doing. That's what I'll do. I guess it's, I realize I'm taking on responsibility of this. I'm signing it no matter what it is. Am I gonna go there and police each one? No, probably most of the events that they're having, I probably attend anyway, so I'm there. So that doesn't really worry me, I guess, but I'll just make sure everything's noted to make sure we cover the village the best we can. I mean, obviously, we've had events here for years, and knock on wood, we haven't had any issues. Lions, firemen, PIBA, baseball, so we've been doing these events. We're just trying to clean up the language, and again, no matter what we do, we're just trying to have something in writing, so we have a baseline, and whatever you guys want me to do is I'll follow through with your wishes on what levels you want these to be filled out at.
Okay, thank you, Ben. Let me ask a question, Trustee Hummel. Are you okay removing all of this as Trustee Saylor would like? Of top of section, page 2.
It seems to me for efficiency's sake, instead of Ben having to go over each one of these and have a verbal conversation with it, which I find more prohibitive than reading it and saying, hey, we do want to have some dice throwing or whatever. Ben could sit there and say, okay, and you can cross that one off. That's much easier than to say, okay, let's go down each one of these and you tell me what. I mean, that seems more draconian than having them in there and making occasional exceptions to it, as opposed to having to tell people you can't do this, you can't do this, you can't do this verbally. That's my opinion. Particularly when we're moving it to only 2, 5, and 7, which I find it hard to be, somebody would complain about that unless there was a special cause kind of thing, in which Ben could use his judgment on that.
Okay, thank you.
I think the current fire chief has seen this and had no issues with it, so I think it's fine to knock out the ones that don't seem to be as important, that don't seem to be as necessary to have written down, and a couple that do. That's my opinion.
Okay. I guess then summarizing all of this discussion, and thanks everybody for the discussion. I would like to then take a motion to approve this facility use agreement with subject to the following modifications, where the top of page 2 includes only 2, 5, and 7, and the rest of the facility use agreement stays the same.
I'll make that motion.
I will second it. Any other discussion?
So my last 2 cents, and then I'll shut up about the whole thing, is I've never rented any facility in Port Edwards, nor do I plan on. I mean, I have no skin in the game. I'm just trying to limit outside issues that could or could not come.
I understand and I agree with that, Trustee Saylor. I think those need to be handled on an individual basis if they come. And they need to be investigated and adjudicated as they come. I think what we're talking about is trying to get this in front of people so they at least understand the basics of what we're expecting.
So what we could add is, and it does, I don't think it has to be in the motion necessarily, but let's check and see if we keep those 3. Let's give it a year and see how that works out. And if there are problems with it, we can always modify it. So that's something else we can do too. This doesn't have to be forever if there's an issue that keeps coming up and up and up and up. So in any
Okay.
case.
So the motion's been moved and seconded that we move this on to the board, draft 2, with the spelling corrections that was made, and the top of page 2 to read only number 2, number 5, and number 7. All those in favor say aye.
Aye.
Aye. Opposed?
Nay.
Okay. Motion is carried 2-1. We will have this discussion at the board. Okay, thank you very much for all of that. Thank you, Attorney Abst. Do we have anything else for Attorney Abst?
So we did skip number 8, but why Attorney App's done, let's talk about 12 and 13, because that's all part of it. Do we want to change our ordinance language?
For the keeping of livestock and poultry, are you talking, or?
No, for adding the facility use underneath our normal ordinances, and then we have underneath the fundraising and activities organization. Number 11 and 12.
I guess if you're asking my opinion on it, I think that it makes sense to have it in the ordinance, although I would suggest more general language that instead of the facilities use agreement, so I'd say any applicable facilities use agreement approved by the village, so that then it can stay in there permanently. So if there isn't one, if you decide, you know what, we're not going to have one, then you don't need to go back and change the ordinance and remove stuff later. Then the committee and the board can be a little bit more nimble on these things. That would be my only recommendation. But otherwise, I'd recommend that it be in those 2 places that if there's an agreement, it be used.
Did you catch that, President Mansell, that we could make a motion with the correct wording?
Yep, you'll have to say it over again, but I think I got a facilities use agreement, not the, so it's a little.
So would you read it, what you would like it to read?
Are you talking to me or Nick?
Either one, because I did not catch it.
I would say instead of, they have to sign the facilities use agreement, I would say any applicable facilities use agreement uh, approved by the village.
And should it be the same statement in both of those sections?
Yeah, I think so.
So the organization is responsible for signing the applicable facility agreement for use of the village property for their, one is saying fundraising event and one is, they're both saying fundraising events.
Well, the question I have for that is if we're gonna use this facilities agreement for both renting out park structures and organizations, do we take fundraising out of the first statement?
I think
Yeah,
so.
I think, that's right. That fundraising is in the first one too, isn't it? Pretty
Yes.
fun. It'd be any events. Fundraising events is pretty narrow. It sounds like it's being used for more than that already, and the intent would be more. So the ordinance should just, the language should just match what it's going to be used for. So if you're only planning on using it for fundraising events, it's fine. But I guess my recommendation would be to use it more broadly, though it's up to the committee and ultimately the board.
I think you are correct, trustee Saylor. We need to remove the fundraising portion of it.
Yeah, I think on both of them. I think if you just have the organization is responsible for signing a facilities use agreement for use of village property for events. For both of them.
Any applicable facilities use agreement?
I think if you just put a facilities like Nick was saying.
Well, this is what he said for me to write down, so that's why. Because it says any applicable facility use
I
agreement.
would just say the use of the word applicable is I could give or take, but any facilities use agreement approved by the village, just so that it's clear that it's a village use agreement if there is one.
Okay. So, again, so if, do you have that exact verbiage so we can
Yep.
get this? Go ahead.
Hold on. The renting organization is responsible for assigning any facilities use agreement approved by the village. Oh, village property, sorry. Facilities use agreement for use of village property for their events. Correct.
Is that Nick?
Say that
Attorney
one
Epps?
more time, Betsy, if you don't mind.
The renting organization is responsible for signing any facilities use agreement approved by the village for the use of village property. For any, if we took out the fundraising for any events, or for their events, sorry.
Yeah, then I think you have it right.
Good.
Okay. So with that, I would guess I would be looking for a motion to add that verbiage to the chapter 12 licenses and permits, section 12.15 of the village ordinances.
Are you
Do
okay
we
with
ha-
that, Eric Saylor?
Can we just combine them or do you want them separate? And can we just make them both? And then
Make
in the
one motion for putting me in both places?
Yeah.
Okay,
So
then go ahead.
if we can do that, I will make the motion to change the facility use agreement language in chapter 12, section 15 and chapter 5, section 513 to read, the renting organization is responsible for signing the village approved facilities use agreement for use of village property for their events.
Thank you. I second that. Any other discussion? Okay,
Did you
all in,
want,
go ahead.
sorry, because it says to be updated yearly, do you want that still, that piece in there?
I think that's understood. It needs to be understood
Okay,
because this is an annual, is it on the,
I just
I
want to
think
make sure.
I
getting
think it
all-
almost has to be filled out for each event.
Yeah, I was gonna say, I think it covers the event, the
The single event.
individual events, I think, is the
Okay.
intent of the
Yeah.
language in the document itself.
Okay,
okay. So all of those in favor of passing that motion as stated by trustee Saylor, say aye.
Aye.
Aye. Opposed? Motion carried. Let's then move on to 13, and I apologize that we missed 8. I will kick it off by saying we were asked to look into an ordinance in the village of keeping of poultry. And we were looking at modifying our ordinances of keeping of livestock and poultry. So the information that was sent out, I will be honest, I did not get through Marshfield's or Nakusa's. My thought is that we need to do something because we already have people that are keeping chickens and we really don't have anything in NR that really does define what we expect. We really have 10.05, noisy animals or fowl, or we have 9.09, animals and poultry not to run at large, and 9.10, keeping of animals and poultry regulated. And it defines that, and it really doesn't do well to define what we expect and how people need to keep them. So I think we need to do something. I don't think we have enough information now to actually push it forward. So I think we should put something together and then let it come through this committee. And some of these are very restrictive. And I think we need to take one, model it after one of these and then make it fit our village. And I will ask for Attorney Abst's concerns, or from a legal standpoint, what, if he can give some input.
Well, my view on this is, so chicken related ordinances come in as many forms as there are municipalities. The importance is just enforcement. And as long as it complies with state law, generally, which, it broadly is pretty, there's some guidance from ATCP and with regards to livestock and so forth. So, Grand Rapids does it a certain way, but generally speaking, to me, I mean, I will say that I'm not sure. I haven't seen issues. I mean, I don't know. There's a bird flu thing going on right now, or has gone on recently, but I haven't seen issues legally come up with respect to poultry around here, in Wisconsin. I'm not aware of any case law on it. I just don't know. I don't know that I can advise you really well in terms of liability, other than to say, generally speaking, you should just commit to whatever it is you're doing. If you have a poultry related ordinance, then Ben and the police department should be enforcing it. Because the problem, when I see problems, it's usually that there are rules that are not being enforced. That's really what it comes down to. And if you don't have any rules, then of course you have kind of the problems of people complaining and there not being any recourse. So I'd say just decide whether you want to be permissive or restrictive. Find a model to go by, and I, I mean, I can tweak it for you if you want, but otherwise, I think this is really about individual like specific local preference, and I can't give you too much more than that at this time.
Okay, thank you. Any other input from Ben, trustee Saylor, trustee Hummel?
So I think one of the repetitive things by looking at all the other municipalities is the size of the property. Grand Rapids is 5 acres, and they said that you could have a chicken coop 25 feet from the house. Marshfield, I don't know, one of them, they all kind of start looking the same as you read them and go over them. One had I guess I don't know which this one was. One had a 200-foot max or minimum distance to a residence. So when you start talking those kind of distances, whatever is agreed upon, if we move forward or not move forward, there's not a lot of properties in town that are of that size. So we're not talking of a lot of I guess I just repeat myself, the properties. So I think we need to make rules on if we can or can't. And I think the first thing comes down to resident size. I know, like, if I lived next door, I mean, I have a little bit more area in between us, but if I lived right on top of each other, like I did on River Drive or whatever, having chickens there may or may not be a good thing. I don't know, because of the traffic, because of whatever. And then now we're starting to govern that. So I think first things in moving forward is to decide if we want to move down this path, or B, the size of the property that would allow it.
I agree with that. Let me ask Attorney Apps one question on the Grand Rapids animal code. When it says number 3, notwithstanding subparagraph 2, that's where the paragraph 2 above is where the 5 acres comes in. So am I reading that correctly, that you can have chickens on less than 5 acres?
Yeah, let me here. It'll be easier for me to just pull it up, because it's hard for me to read there. Let's see. Where's the
on page 5 of 9, it was in. So I don't know. I did not catch that there was a actual size of property. It's just that you needed a certain size coop and you can't have roosters. And I think you're right, Trustee Saylor, that we need to at least decide whether we want to do this. And I think we need some uniformity.
Yeah, I will say that I think you're right about that, but where is it?
Grand Rapids is 2 acres, and it's on, I don't know what page this is, page 5 of 9, 8 point.
Yeah, so
8.11.
So here's what that's saying is that agricultural animals require 5 acres, but chickens are an exception, is what that's saying. So
yes.
Yeah, so the 5 acres, so typically chickens are utilized, are applied as a lone exception in a number of places where in small areas. But I think that it's beneficial to have, it's still got to follow the setback requirements. They have to be enclosed. I mean, I don't know. Although in my experience, chicken owners who do not keep their chickens enclosed generally find that there are neighborhood dogs that will punish them for that, and they only need to learn once. But you just need to decide what the specific requirements are. I mean, I honestly, I think the Grand Rapids is pretty detailed and is a pretty good guide to go by, but it's really up to you guys.
Yeah, the Grand Rapids one is pretty restrictive. I think we as a village need to decide, 1, if we want to do it, 2, how restrictive or permissive we want to be, and understanding that the biggest thing for chickens is allowing them without having disturbances to nearby properties.
Let me make a couple comments.
Oh,
go ahead,
Chairman. I apologize. I just want to, I'm running a little low on time, so I'm wondering if anybody has additional questions for me before anybody else dives in. I don't think I have anything specific to add on the 160 Market Avenue that I think that Ben doesn't already know, because I know we've discussed that in some detail.
Okay, thank you. Anything else for Attorney Abst?
Nope.
Thank you for your
Thank you.
time
Thank
and
you,
we
Scott.
appreciate it.
Thank you.
Thank you. Go ahead. Somebody was speaking.
Yeah, so a couple highlights that I did in the Grand Rapids. A 500-foot radius, we send letters out to all the neighbors, letting them know this is going on. The plan commission, the applications get sent to them. That's the final decision, so that's something new. The final decision on the permit will be made by the plan commission, recorded form and signed by the plan commission chairman. They also have a $20 permit per year. A coop or attached enclosure shall not be closer than 25 feet to a residential dwelling or adjacent lot line. I think that's something that Mr. Saylor was saying. Obviously Grand Rapids has a lot of forms on livestock. What kind of chickens is, and I'm not an expert on chickens, but definitely a lot of language on what the animal is and the livestock and things like that. I did have a brief conversation with Grand Rapids on this. The permitting, the applications, going out, obviously if somebody applies, I need to go out there, take a picture of the property. Where's the coop gonna be? How close is it to the lot line? Where the neighbors are gonna be? I mean, I'm not here to say yes or no. I'm just giving some highlights of some of the actions that are gonna take place if we go with that one. Definitely
Yes.
the policing on anyone is always an issue, right? I mean, we deal with that on a day-to-day basis here on other ordinances. So them are just some of the points that I want to bring to your attention that, the
This
planning
is,
commission. You can go ahead, Mr. John.
this is very restrictive. I agree with you, Ben. This is very restrictive and it does put a burden on the village to make sure that we're following it. But we need to, personally, I think we need to put something in place so we have everybody understand if they're going to keep chickens, this is what's required. Whether we go very restrictive, which has its own set of issues and concerns, or we go very permissive, which is where we are, because we really don't require anything. I think as more and more people may want to keep chickens, I think we need to standardize it. So I'm not saying we go with this. I mean, it's a starting point, but I think we can modify it for what we feel the village of Port Edwards would want and need.
I think Grand Rapids is a lot. If you're getting plan commission involved and mapping out properties and getting permission from your neighbors. I mean, I don't need to get permission from my neighbors for my dogs or my cats. But I think between Rapids and Nakusa, it seems to be it laid out well. And it doesn't seem to be a lot of unnecessary extra work for staff. That's just what I've noticed. And, obviously I think the big one is making sure that you're keeping them in a coop and away from the lot line. And, because if you look at it, Rapids has pretty small lots as well, when you're in the city. For adult chickens, no roosters, obviously, those types of things. I think those are the things we should be really looking at. These permits and commissions, and that seems like a lot to me. And the livestock premise registration application is a lot to do for chickens. But that's just my 2 cents.
Okay. So is there agreement from this committee that we should do something, whether it's permissive or restrictive, to at least let people know what it requires to keep chickens?
We're looking at a whole ordinance change here and adding this to the ordinance. I mean, there's a lot of steps to this, right? And right now in our ordinance, however you read it, I believe no chickens are allowed. I mean, it doesn't say that, but if you read it, how it's been enforced in the past, shall not keep possession of livestock within the village except agricultural areas, right? So
Well, that's,
the way we manage it right now is agricultural areas can have it. I don't 100% know. I've heard stories of it. I mean, I don't go in people's backyards behind fences, I guess. Have we had any complaints? I've talked to the PD. We haven't had any complaints come through the PD of saying there's chickens, right? So I'm not gonna make any kind of assumptions on that. But again, we have to decide, are we gonna change the ordinance to allow chickens? And then again, we have to decide which ordinance we're gonna follow. I mean, there's definitely a lot here on the table and a lot of different opinions, so I think for staffing purposes, we gotta come up, and if you guys want to move this forward, you have to give some direction to myself and staff so we can take it back and start, combining what high points. I mean, this is gonna, we just seen how long it took to do a facilities agreement. I mean, this is gonna be a lot of back and forth trying to get language added unless there's highlights. We're gonna take somebody's ordinance, one or another's municipalities, and just copy it word for word, or if we're gonna use bits and pieces of each one. I believe Rapids does have some setbacks and other things too, I believe. But that's just my 2 cents with, as staffing, we need to know which direction you guys want us to move forward and start combining things, or how would you like to present this?
I will say that we really don't have anything in our ordinances that I found, unless I didn't find the right spot, of chickens, because livestock is horses, cattle, swine, sheep, and goats. It's defined in 9.10. And wild animals, we don't really define poultry or chicken. There's only one in 9.09. No person is having his possession or under his control any animal or fowl shall allow the same to run at large in the village. And then it talks about 10.05 noisy animals or fowl. So it really doesn't talk about chickens, because there's every one of these that I see delineates chickens from livestock. Agricultural animals. So I think personally, I think something should be done about chickens, and at least have a standard. And it could be very simple.
Maybe you could refresh my memory. Are we addressing this because a citizen brought it up and wants to do this, or how did we arrive at dealing with chickens right now?
I was
go
reached
ahead.
out to by a citizen,
that's right.
before, and this has happened a few times before. It's
Okay.
just, there is a chicken movement, so to speak, but it has been brought up by a citizen recently, and even so, I think 2 years ago as well, so.
Yeah. Well, if the citizens are asking about it, certainly in my mind, then we need to address it.
And there are people that have chickens, what I'm hearing from rumblings. And if they're doing it, then how do we make sure that there's at least some standard if people are going to do it? So I guess I'm not looking for a motion. I think we need to consider it in the next PLP meeting, whoever's running that. We can bring it up and discuss it, and those members can talk about whether they want it restrictive or permissive. I don't think it should be. We would have to determine where we put it in the ordinances. Go ahead, President Mansell.
I guess for Ben's sake, like, he has just kind of a direction on which way to go. So that him and the staff can kind of figure out some kind of paperwork and then bring that forward to the next board meeting or committee meeting. So I guess trying to get a consensus of which direction we go with, I think would be helpful for staff.
Correct. That's my thought also. What is the thoughts of the two other trustees? Do we want to be permissive or do we want to be restrictive? Because it looks like there's both of these, and we could model it after whichever one we choose to go.
I really don't know enough to be able to say what quote permissive is or what restrictive is. So now that I've heard tonight, I can go back a second time and read this and probably get a better idea of what that is, but I have no firm opinion about that right now, but that's just me.
Well, let me back up, and thank you. But let me back up one. Do you think we need to do anything?
Yes, I do, because as I said, if citizens brought it up, I think it's something we've got to address.
Okay, Trustee Saylor?
I guess for me to even consider it, we have to figure out the basic size of your property. If it's not going to be all or none. So I think that needs to be decided first, and then we can figure out how many properties qualify for that. Yeah, we can change some of the wording in the ordinance, but let's see how many properties actually qualify, whatever the committee is trying to decide.
We could allow it on any property. It's up to us to decide and put that in the ordinance. It's just, are we gonna want them contained? Are we gonna want them, any setbacks? How many you're gonna allow? I mean,
Yeah, there's a
you
lot
could
of
just,
discussion, a lot of
yeah,
questions.
you could say very permissive is we'll allow chickens and they can run free range. But then that opens up a whole other Pandora's box.
If we're looking at permissive or restrictive, to me, Grand Rapids, Marshfield are restrictive. There's a lot of work to be done. There's a lot of measurements and all that, where Nakusa and Rapids are a little more permissive. They're not necessarily free range, do what you want. There are set rules, but they're not as time intensive for our staff or even for the potential chicken keepers. It's pretty, I mean, I've seen having chickens, I've seen a lot of different legislative things coming out on these. And I mean, the common theme is they have to be in a coop. You can't have a rooster anywhere from 4 to 6, but if you understand chicken coops, those ones that they sell at Tractor Supply and Fleet Farm generally only allow you to have 3 or 4 max for the space that they have in there. And then it's keeping it away from lot lines, and it doesn't matter how big the lot is, but it's, you have to say 25 feet from a lot line on either side. Or all 4 sides, or however it is. And I think it has to be in your backyard. It can't be like right in the front yard. So I mean, those are pretty cut and dry things that I think we could have that discussion today to kind of go forward a little bit and give staff a direction on which way to go with that. But that's just my take.
I agree with that. My thought process is that we go into the rapids or was it Nakusas? I don't have that in front of me, where
Yep.
we put those specific things in. And so we have some uniformity. You have to have them in a coop. They have to be all the things you just said. And we could model it after, let's say rapids, and come back in next and at least have a start.
Yep.
And we can discuss it from there. So giving direction to Ben and the village staff, I would model it with those 5 or 6 things, basically modeling it after rapids, and then come back with a presentation for the village of Port Edwards, regulating chickens or whatever you want to call it. So, and then we can take it from there. Have to be in the backyard, off the lot line, have to be kept in a coop. They have to be kept clean, no roosters.
Yep.
And whether we want a permit or not, it probably require one. I don't think we need to, we can have a discussion whether it needs to be renewed yearly or not. Thoughts? Because we're getting very long here on this meeting, but we had a lot to cover.
I guess my opinion would be to make it more restrictive than permissive, just because, I mean, just like the facilities agreement, the agreement was to add limitations. So the more limitations, the better, so to speak. So having limitations here, I think keeps everybody kind of on the same page.
Okay. Trustee Hummel?
I'm sorry, I'm not an agriculturist, so I'm still struggling here with rereading these. I think it's probably easier, however, to look at a least restrictive and add things to it than taking a restrictive one and eliminating things from it. So, I'm fine either way. If you want to take whichever one you want to take, I'm betting $1 we'll probably want to add some things to the least restrictive. The more restrictive, I hear what Eric Saylor's saying. To me, size of the lot is a big deal. So you can still have a least restrictive one, but still have the size of a lot be whatever we decide we want it to be. And so, yeah, you tell me which ones to look at and what ones are gonna work on, and then I think we need a discussion about lot size, as Eric Saylor said, and whether or not, neighbors get an opportunity to weigh in on, their reaction.
Okay, thank you for your input. I think, and the unknown here is we're coming into an election and the upcoming president, whoever that is, can rearrange these committees. So we may not be the ones using it, looking at this next time, or we may be. So I would recommend that we come back with a version of a proposal for the village, and then that discussion, we can add to it what we want and be as restrictive as we want. Until then, I think we should review these and get a feeling from ourselves and from others' discussions what we see is best for the village. Does that make sense?
I think
I'm
the first
fine with
question you gotta ask is, do we want to allow chickens or not?
Correct.
If we don't, then we can make some changes to the ordinances, and if we do, then we gotta make changes to the ordinance.
Right. Exactly. Right now, we are allowing chickens, from what I understand. We just don't have any ordinances that pertain to them.
Chickens are they're not allowed in residential area right now.
Problem is, I don't think there's enforcement, or if there's, you just don't know that they're there.
So
If somebody's
where's that in the
yard,
ordinances?
Well, you can decipher how you want. I get the last board meeting, former Chief Zerflu said,
Yeah,
poultry regulated, basically, and again, I understand where you're coming from, but no person shall keep his personal livestock without village except in agricultural districts. Maybe it's not interpreted the way it's read, but I guess as staff prior to my being here in the village, police department, that's how they've restricted it. And again, at this point, I haven't had anybody complaints about chickens. I know there's some in the egg areas, which it's accepted, but in residential area, I haven't had any complaints or visual from me driving around the streets, I guess, at this
Yeah.
point.
Well, yeah, then we need to define it. I mean, Trustee Saylor's right, but the way I read 9.10 is livestock is defined in the definitions section to include horses, cattle, swine, sheep, and goats. Doesn't say anything about chickens. And then 2, no person shall keep in his possession any livestock within the village except an agricultural district. So there's legally, that doesn't state anything about keeping chickens.
I would agree. I mean, this was brought up again 3 years ago. I think
mhm.
President Mantle said, I mean, it was brought up having chickens, and at that point it was agreed that we weren't changing any ordinances. Our ordinance was read like this. I do agree we should update it, but that was how it was proceeded.
Yep.
I don't know if Trustee Saylor was on the board at that time, but it did come up for conversation. I don't remember if it came to vote. I think it got died in a committee level, if I remember correctly, but I could be wrong.
Again,
It was a resident that came to me or whatever during a basketball game, asked about it, and then we asked her to come and give the reasonings why, and then that
Yeah.
person didn't show up, and so we just
Yeah.
moved on.
do we want, that's a very good question. And this committee is a subset of the board, and the board is the one that's going to decide if we really want to allow chickens or not.
Well, and I
mean,
think there's legislature coming through that the state may make municipalities allow chickens to some degree, but it's up to us how, when, how many, those types of things is from what I've been reading. So I think it's coming down the pike anyway. It's just if we can put our own parameters around it before it gets there, I think that would be best.
That's a very important piece of information, that if we're going to be required to, then we just need to put the ordinance in place the way we want it. So what I'm hearing is, yes, I think we want to do something with chickens because we may be asked to. And then if we do that, then we can bring it to the board and then it can be actually accepted or shot down that we don't want chickens there until we're told to by the state. So Ben, do you have I know it's about as clear as mud, but do you have a path forward?
I got, I mean, from your guys' conversation, there's a lot of list of questions, setbacks and this and that. I mean, we can take rapids is which that seemed to be, but then there was also questions of lot size and other things. So taking rapids and then giving the 10 different items that you guys suggested after listening, we'd have a bunch of open, what lot size, what we want to do here, permitting things like that. So I guess for a start point, if that's your direction, Wisconsin Rapids ordinance, but then there's 10 other items that I've heard you guys list that need to be
Yeah.
decided to add to the ordinance. So I mean, for the next committee, whoever it is, I guess I could have it on the agenda. Discuss and possible motion on a chicken ordinance and bring Wisconsin Rapids in, and I could have 10 lines underneath it with lot sizes and other things, whoever, I guess, as the chairman prior to the meeting, we could come up with some agenda items. If you guys have any other ones, lot sizes and regulations, you could email them to me and I could add them onto the next agenda and packet. I guess that's what I've come out of this. I don't know if I'm right or wrong, trustee Saylor and trustee Humble. But again, we gotta start somewhere, but it does come back to, are we gonna allow, at the end of the day, the motion has to start, are we gonna allow chickens or not before the effort level goes at a high level, I guess. That's,
Let me ask a procedural question. Yes, it has to come through this committee, whoever's on it, but this really could this would be a working meeting to come up with these suggested ordinances. Is that something we could be sitting in this meeting for 2 hours having discussions about this? Is that something that could be done outside of the committee and then brought to the committee?
Well, you'd have to notice any kind of committee, so I think it'd be easier to. First, everybody has to educate themselves on the different ordinances that are available. And then staff is, the chairman can work with staff, or I can work with staff on doing a proposed budget, which I would be more than happy to do. I could, not budget, I'm sorry, ordinance, which I'm more than happy to do. Cause I'm a part of all the chicken things. And then propose that to the next committee meeting. I think if we work too much outside of, we would just have to schedule another like working session meeting if you want all of us at the table working on that particular subject.
I don't think it's.
be illegal quorum if you guys are replying back to emails as a group to me. So we
Right.
have to meet in person. We can't.
Right.
You could stop my office and say, Ben, add this one at a time personally, I could do it, but we can't have any kind of working relationship as a group or an email together, if that makes sense. And
Yeah, it does, but like lot size. I don't know what the average lot size in the village is, and if we want to allow it, everybody's gonna have a different opinion on what lot size and how many chickens they should allow on it. So, I mean, and we gotta start somewhere, and then we can have that discussion, and it just may be a longer meeting.
If you would like, Chairman Hess, I can work on something again, cause I'm in that world with agriculture, more cause I'm agriculture, and I can look at what's out there. I can have draft 1, draft 2, draft 3, and then we can go and kind of combine a couple, have a really restricted one, have a permissive one. I can do that. That way we're not making staff work on chicken related things for
Yeah.
hours too, if you're okay with it.
I would appreciate that.
Okay.
The issue I have with that though is that's work, or a lot of work that's happening prior to the decision if we are gonna allow to have chickens or not. I personally would like to see, just like when the last resident, if the people that are interested in having chickens come to the next meeting, and we can ask them their reasonings why they want chickens or this, that, or whatever, and just get an overall feeling, and then we can decide if we're gonna have chickens or not. And if it's not, then we can adjust the ordinances accordingly. And if it is, then we can start down that path.
I'm not saying we have to take the residents out of it. I'm just saying that way I can do that work. We can have options available. of course, encourage residents to come to the next meeting and see what they want. And then either we scrap it or we pick one of those ones and we've already have the ball rolling versus now we're right back to square one again. And again, another reason why this kind of got brought up is because there is a statewide, I'm reading it right now, a statewide proposal would allow residents to keep up to 4 chickens or quails. Municipalities could still have requirements like obtaining a permit, notifying neighbors, and keeping areas clean. But ultimately, this is coming down the pike and it's making progress of we're gonna have to allow it anyway, so we might as well
Be ready.
be ready for it.
Yeah.
And again, if the state ends up pulling it before we make a final decision or final requirements that we as Port Edwards wants, that can come up. But I think if I can at least do that and get that part rolling, because again, that's kind of my wheelhouse in the world that I live in. And at least just have documents ready, just like we have the facilities use agreement. We had different options to look at, and we had different options and we kind of whittled through that as well. So I think I'm willing to do that and go ahead and have a good, better, best, or really restrictive, medium restrictive, no restrictive type of options for everybody, and then bring that to the table and I can take a better look at what's going around. Obviously, we have what's going around in our area, but then as a statewide thing too, keep an eye on that.
I'm in favor of that. I'll speak from my opinion, just so we're ahead of the game. Let me ask one question, just get a consensus of the group. Is the trustees on this committee in favor or not in favor of having chickens in the village? Trustee Hummel? I'll start with you. What's your thoughts?
I'll go first.
Yeah, please.
Please.
And then you can use my words or whatever, or disagree. So right now for the last, who knows how many years, 100 years, whatever this ordinance has been on the books, we have not allowed chickens. So until somebody comes and gives me reasonings why we should allow chickens, good, bad, or indifferent, that's when we make a decision on to do it. I'm not against it. I'm not for it. I don't see the necessity to do work to put the cart before the horse per se if we keep it the same. I mean, 3 years ago is when the chicken talk came up. So, I mean, if we would have done all that stuff, nothing's happened since then. That's just my opinion.
Okay, thank you. I appreciate that.
So I'm gonna do this from a real personal standpoint. You know, if you were talking about me personally, would I want chickens next door to me? I would say, no, I don't. I'm not interested in the noise and so forth. However, you could counter that and say, well, don't you live right where geese are? And I go, yeah, and actually I'm kind of used to them at 2 or 3 in the morning, making noises and it doesn't bother me at all. So I could go either way with this, but part of it to me is like, if I look at a least restrictive document and it still doesn't, I was gonna say smell right to me, I would probably say no. But that's why it would be valuable to see, let's see what a draft document would look like, and then I might say, no, I'm just not into it. I just don't see it at all, or I could say, well, yeah, that makes sense to me. So I know I'm wishy-washy about it, but that's kind of where I am.
And I appreciate both your inputs. My perspective on it is I think that I don't care if people have chickens or do have chickens, as long as there's an ordinance around it. Is there a need for it? We have not allowed them. I think some people are allowing them, is what my understanding is. So we either need to deal with that, or we need to put something in place to describe what we expect from those people that do have chickens. And I appreciate what you were saying, trustee Saylor, that we have never allowed them and you would like to understand why. But we did have one resident was asking when we were going to have an ordinance about chickens. We could communicate with him and find out if he is planning on having chickens and have him explain to us why he wants to. Do you know the person involved in that, Betsy?
I do. I can get a hold of them. And I can get a hold
Okay.
of the other residents that have also asked over the years. Cause I've gotten a lot of messages about it recently. Because I think of the chicken crisis, so to speak. So I can reach out to all of them and see, what they would like. And then obviously people who are against it can come and give their opinion as well.
That would be appropriate at this committee level if people want to come and tell us why they want chickens. I don't see any harm in trying to get ahead of it, especially if the state is really considering it. Is that a proposal that's going to the legislator?
I believe, so this was on March 19th. Article that I read, and I can do some digging to see how far they are in that process, but from what I understand is it was in a bill that's gonna be proposed to legislators, yeah.
So it's made it out of committee and it's in a bill.
From my understanding, but again, I will double check, and even if I find out that information, I can email that out to the committee as soon as I do.
Because that makes a difference. We
Correct.
could be forced into doing this if that legislation passes.
Correct.
Okay. And again, I apologize for the length of this meeting. It was good discussion, but
Are we gonna talk about number 8, updating 160 Market Ave?
yes, please.
So I sent an email out to you guys, I think right after last meeting, that, 160 Market, owners did reach out to me, meeting with contractors, this week. I did see, 3 or 4 contractor trucks over there. I did not, go over there, but I did see contractors over there. So at this point, there was some positive, activity over there. I'll follow back up with him in the next week or so and see what he learned from his contractor meetings. So, I'm guessing he asked for proposals from the contractors, so he's waiting for those numbers to come back, and then, I will stick after him to make sure that he's, putting something together. Obviously, the citations and ordinances are still stacking up from the police department. That hasn't changed. So he knows that the tickets are still there. And, I guess I'll give him a little time here, a week or two, to let his contractors get him prices back, and then hopefully we can have a conversation. Hopefully in the next meeting, I can bring an update from the owner to where he's at on that property. So again, I'm staying in touch with him, and kind of letting him get his prices and see what he comes back at us at. And again, I've had conversation with Nick, the same thing is there, right? It's a matter of, how much money does the village want to invest in getting these properties back, and then what we can do when we get with them, right? So obviously the next committee is gonna have, some decisions to make. We talked about it tonight when it's the cyber one and it's these properties. From a legal point, we have to decide what the village wants to invest from legal and push these properties. So you guys just need to keep me aware. I'll keep legal involved in what we're doing, come up with ideas, and, keep forcing these properties. But I guess at the end of the day, like Nick said, it's a matter of how much money we want to spend on these buildings, and if we get these buildings back, is that the direction we want to go? So, a lot of good topics tonight and a lot of good information for the next committee moving forward, in the next upcoming years.
Okay. Thank you very much, Ben. Okay, any old business? Hearing nothing. Go ahead.
Nothing that I had, Chairman.
Any new business? Hearing nothing. Any correspondence? I did not receive any. Other than the chickens, which was a while ago.
Mhm.
Betsy did. Future agenda items, do you have a list of those? I did not write them down.
So it'll be DMI will still be on there, 160 Market, Cyber One, and then discussion on and possible motion of a chicken ordinance livestock. So those will be the 4 items that we'll have on as of now, and I guess whoever the new chairman is, I'll get with them before the next meeting and add any, other, items they have. And I'll make sure that I have, Cyber One information. If it's a new committee, I'll try to get them up to date as soon as I can, with where that agreement is and have some packets. Obviously, if it's a new committee, I need to get them up to date before they can make a decision right away in their first meeting. So I'll try to get that stuff out once the committees are, put together.
Okay, thank you very much. And next meeting date is to be determined. I
Correct.
don't think we're gonna set one, no. So with that, and if there's no objections, I will adjourn at 6:24.
Wow.
Thank you very much.
Thanks, guys. See ya.